The Superman copyright battle. This video is going to talk about why it's happening and where we are today. There's actually a copyright battle over the copyrights related to Superman. My name is Derek Fahey, and this video is going to be a short video on that battle between the artists and their estates and DC Comics, the owner of the copyrights or some copyrights, and then how it relates to your business. So first off, in the 1930s, two creators created the Superman concept, and they sold as an assignment to DC Comics the rights for a flat fee of $130. Can you believe that? Fast forward to, well, by the way, that's right. Those rights were sold and they were not receiving any royalties. Fast forward to 1978. Eventually, DC Comics actually succumbed to some public pressure and gave some rights to the estate. Fast forward to the late 90s, until 2008 actually, and the estates and the authors of the estates sued DC Comics under the copyright statute to have their rights terminate, or to terminate the assignment. In copyright law, there's a statute that says 35 years. After 35 years, you can actually have the assignment revert back to the author. And why is that out there? It's really meant to protect in situations where some rights are sold and then somebody makes billions of dollars on it, and it affords some rights to the actual author to be able to claw back that information or have the copyrights revert back to that particular author. So they did that, but that's good for the estate, that they're able to have certain rights and receive royalties based upon that statute. But there's limits to that. There's actually limits to that, or what was reverted back. Anything was created after the assignment that was created by DC Comics under work for hire, like the Fortress of Solitude, that concept that was created after would be considered work for hire and owned by DC Comics. There's actually limits to what the authors actually have rights to. Now, what does that mean for you and your business? Well, in certain cases, certain rights are owned by the employer. In certain cases, they're not. So, for example, if you hire an independent contractor to write software code to create some sort of app, if it's an independent contractor, the rights actually are owned by the independent contractor unless you get an agreement transferring the rights to you. In certain cases, it can be considered a work for hire. In certain cases, it's just an assignment. You always want to try to push for a work for hire if you can, or try to say it will be a work for hire, and then if not, it will be an assignment. And the reason why is, if it's classified as a work for hire, there's no like reversion. There's no clawback or termination provision for work for hire works of art. So push for the work for hire. Sometimes you just can't do that. Okay, you actually have to have the assignment agreement transferring the rights. Now, in an assignment agreement, when you transfer the rights as an assignment agreement, unfortunately, you have that termination provision that says after 35 years, the author can actually, if they give notice that they're getting the information back or want the information back or terminating the assignment, they actually have the right to do that. One way you can totally avoid that is having employees that are actually creating the work in the scope of employment. If you have an employee that's creating some sort of software code as a matter of right, because you're the employer and they're working for you under an employee-employer relationship, those rights automatically go to you as a work for hire, and there's no reversion or termination provision that would be applicable in that particular case. So one reason why you may want to consider having employees or classifying people as employees in order to keep that right under your business. Just something to think about. Currently, the state of the Superman saga essentially is actually recently, based upon an agreement that was signed in 1992, one of the authors actually sued in British court to try to actually have some additional rights revert back to the author's estate. So that case was actually dismissed. So the saga continues. Just remember that when you're dealing with work for hire things or dealing with works of art, try to push it for work for hire if you can. If you have any questions about how to make that happen as a work for hire, please reach out to me. My name is Derek Fahey. I'm a patent and IP attorney with the Plus IP firm. And thank you for watching. And if you like this video, please like and subscribe. It helps my business and my family. Thanks so much.